All right, so this time we will talk about chapter 2 of the book, which talks about the sources of international law. So what are the sources of international law as distinguished from domestic law? It is relatively easier to find domestic law because they are generally found in statute books and in collections of court decisions. International law, there is no central legislative, executive, or judicial structure, making it difficult to locate the source of PIL. The problem is further heightened by the constantly changing state of world affairs and competing sovereignties. So this is basically the reason why we have a controversy of questioning whether international law is really a law, because when we conceptualize law, we are contemplating of something that is, of course, made and created by a legislative body. However, in international law, there is no specific legislative department or any structure in the international system which is vested with the authority to create these laws, unlike or in contrast to domestic law. For domestic law, it's much more easier to identify because, again, um, uh, we have the three branches of government, and we know in the very first place who makes the law, who debate about the law, in who intervenes in the lawmaking process, and etc., etc. But in international law, there is no really there's really no hard and fast rule with respect to determining what are those international policies and international law, which serves as the rule of conduct for each state. Okay, so what are the sources of international law? There are classification of sources. We have material and formal sources. When we talk about formal sources, this refer to various processes by which rules come into existence. For example, legislation, treaty making, judicial decision making, and state practice. While material sources, on the other hand, concerned with identification or substance and content of the obligation, also called evidence or international law. So those are the classification. What are the conditions for legal principles? It's laid down by the doctrine of sources. These conditions are the observable manifestations of the wills of the state as revealed in the process by which norms are formed, treaties, and customs. So basically, the sources or the very root of international law is it's based on, of course, treaties, and it's based on the customs or the practices, okay, or the common practices of the states in the international community. Okay. Another distinction that is, of course, can be observed in international law in contrast to domestic law is that for domestic law, the enforcement in case of any violation thereof is clear. So perhaps if you violate domestically, you can be imprisoned, or perhaps you can pay fine, community service, etc. But in international law, there is no such thing as that because it has no clear enforcement power. And in case of treaties, for instance, it can only bind parties in the treaty or in that agreement. But it has no clear enforcement power. You cannot imprison, of course, your um your neighboring state or the other party who allegedly violated the provision of the treaty, because again, it has no clear and it has no definite enforcement power. Verification process, inductive and positivistic, finding what laws the states have created and what laws they're willing to place themselves under. So it is also the proof that international law is characterized by individualism, because of course these nations, these member states of international community are sovereign in nature, and we all know no, we have this very, very important principle of non-intervention because of the sovereignty that is of course that the state possesses. Of course, neither state party can, of course, intervene or uh, participate in the purely domestic affairs or thing. So under Article 38, Paragraph 1 of the Statute of International Court of Justice, ICJ. By the way, ICJ is an organ of the United Nations. No, it's under UN. Most widely accepted statement in the sources of international law, however, Article 38 is primarily a directive. It does not speak of actual sources, but directs the ICJ on how to resolve conflicts brought before it. But usually the cases, not usually, but the cases are catered in the International Court of Justice or ICJ are mostly um, things which have something to do with the conflict of arising from treaties, arising from executive agreements, or perhaps sovereign conflict or maritime dispute, etc., etc. So these are the cases under the ICJ. Article also, the same article enumerates the following as applicable to disputes before it without prejudice to the power of the court to decide ex equo et bono for the right and good if the parties agree thereto. So it will always boils down to the principle of consent. No, again, we also have consensual theory in international relation because again, enforcement, it has no place, no, in international law, but it's all of course it's permitted should if there is consent by the other party. International conventions, whether general or particular, establishing rules expressly recognized by contesting states. And also international custom as evidence of a general practice accepted as law. We also have general principles of law recognized by civilized nations and judicial decisions and teachings of highly qualified publicists of various nations as subsidiary means and subject to the provisions of Article 59, which states that the decision of the ICJ is only res judicata as between the parties and with respect only to that particular case. So these are the sources, basically. Okay, these are the sources of international law. Okay, so we have primary or direct resources, and we also have secondary sources as classification of international law. So number one, we have treaties. Not every treaty can be considered as direct source of international law, as it is not always concluded by a great body of states. So there are, of course, we also have two classifications of treaties, right? We have multilateral treaty and bilateral treaty. Okay, that's why it's not really, not all treaties are considered to be as a primary source, because some treaties can only include maybe around 5 countries or 10 countries or 10 states. No, but so in effect, it does not really bind the other states who are not privy or who are not parties to that particular agreement. So when can a bilateral treaty become a primary source? Of course, there is an exception. No, although not all treaties are considered to be a primary source, but when can we consider it as a bilateral treaty as a primary source? First, if they are of the same nature, contain practically uniform provisions, and they're concluded by a substantial number of states, albeit separately. For example, there is a treaty, specific treaty between the Southeast Asian nation to avoid use of force, no, to prevent use of force. So despite the fact that the treaty only covers all the members of the Southeast Asian region, no, so it doesn't make, or it doesn't preclude that treaty to become or to be classified as a primary source, because as we all know, the use of force has the same nature and concept of what we know as considered to be an international customary law. So it is really recognized by almost all the members of the international community. Also have customs. A custom is a practice which has grown up between states and has come to be accepted as binding by the parties by the mere fact of persistent usage over a long period of time. So also, if we look at it in a particular perspective. For example, in our community, we do have different customs, right? So customs is product, of course, of the practices of our um, of the people in a certain community. So what's the example of a custom? We have exterritoriality, the practice of granting immunities to foreign heads of states or diplomats. In fact, the Philippines have agreed to this, no? The exterritoriality. For instance, um, our Republic Act number 75, we provide immunities to ambassadors, heads of the state, um, what else? Charge the affairs, okay? But consuls are, of course, not subject to immunity from suit, no? Only ambassadors o katong charge the affairs. For example, the Pope, no? They are exempted. If they committed a crime in the Philippines, then we grant them immunity. Okay, so that's what we call exterritoriality. So if they committed a crime, we are not in any way authorized to rule over their case, but they should be sent to their origin or to their country. So what are the material factors of customs? When can we consider a certain practice is custom? We have the factor of duration. No, it can be long or short duration. Customary law as a result of long immemorial practice. For example, the Paquete Havana, where uh, they resolved the issues whether or not fishing smacks were subject to capture by armed vessels. Of course, this for example, this is the exclusion of the fishing vessel as a reward for the price of war. No, so by ancient usage centuries ago, gradually ripening into a rule of international law, coast fishing vessels pursuing their vacation has been recognized as exempt, no, or excluded from capture as price of war. So despite the short duration, it doesn't preclude a certain practice from being considered as a customary law. So we also have the case of North Sea Continental Shelf. It's a decision coming from the ICJ, and it states the passage of only a short time is not a bar to the formation of custom on the basis of what was purely a conventional rule, so long as state practice should have been both extensive and virtually uniform. It should show that there is general recognition that our rule of law or legal obligation is involved. For example, the principle of non-intervention, although for instance, it has been only entered by two nations. They had a specific agreement between this, and kahit pa, no, it's only for a short period of time. But since it has been recognized, it has been accepted by a community of nations, then even with that short period of time, okay, it can still be considered as customary law. You get that? Okay. We also have consistency as a factor of custom. It involves continuity and repetition. So when we say practice, when we say a specific conduct or an old conduct, or there should be a continuation and repetitive factor or repetition, no, as later in the asylum case. This also I think it's between Colombian ambassador and the Peruvian government. So the issue in this case is whether or not Colombian ambassador could claim De La Torre, alleged mastermind of military rebellion in Peru, as a political refugee, granting him asylum and safe passage over the objections of the Peruvian government, who disputed Colombia's claim. So what happened here? Itong si De La Torre was charged with military rebellion. Okay, so he was charged rebellion, and a Colombian ambassador based from Peru, no, offered an asylum to the said accused, in this case De La Torre. So it was of course opposed by the Peruvian government. It disputed the claim of Colombian ambassador. So what's the ruling? Kasi gusto ni Colombian ambassador murag sagipin niya si De La Torre para he will grant, okay, parang may refuge na sa Delatore. Okay? So, what's the ruling? The ruling of ICJ was against Colombia because they didn't prove that there was constant and uniform practice of unilateral qualification as a right of the state of refuge and an obligation upon the territorial state. So it's like condoning the person. No? So, for example, nag-commit ka og crime sa United States, for example, United States, and then only because you have been offered or granted asylum from an ambassador based in US, then it will already exculpate you from the crime, no? Meaning ipawalang sala ka sa crime na yan. So in this case, it was found out na, or it was ruled by the court that there's no, this is not the custom, no, or this is not how international community resolve these types of scenarios or cases, and it was not proven that it is a state or international community practice. So since it is not proven that it's a constant and uniform practice, then it's not considered as a customary law. So it ruled against Colombia. Okay, so the offer of asylum was not, of course, granted. Uniformity and generality need not be complete or just. So going back, no, to the although going back to the case of De La Torre, okay, because it is said that you cannot unilaterally grant, asylum, and it will be, of course, kanang binding to the Peruvian government, because in effect you are actually making or rendering the laws of the Peruvian government futile. No, parang you are making their laws useless because just because you grant that person, De La Torre, asylum. Okay, so we also have the factor of generality and uniformity. So, however, it need not be complete, but it is required that it should be substantial enough. So let's say the case of Nicaragua versus US. Still, it's an ICJ case. To deduce the existence of customary law, it is sufficient that the conduct of states should be consistent with such rules, that instances of state conduct inconsistent with it should be considered as breaches of the rule, not proof a new rule in place. So again, it is sufficient that the conduct of states should be consistent with such rules and that instances, okay, of state conduct. So there should be uniformity and generality, meaning it is considered and it is recognized and is accepted by the majority of the member states in the international community. Otherwise, kung, for example, European lang na siya nga practice, European continent or Asian continent lang na siya nga practice, certain action, no? Or, for example, assuming that the use of nuclear weapons is only allowed in East Asia, no, in East Asia, but the remaining parts of Asia do not allow nuclear weapons, and even the Western countries, Western side of the world, and even the African continent do not allow nuclear weapons. So kung sa East China lang na siya, then it's not considered as customary law because it lacks the factor of generality. Okay. So we also have general principles of law. This is still part of primary sources. They have nevertheless become universal in application because of the unilateral decision of a considerable number of states to adopt and observe them in recognition of their intrinsic merit. Concepts like prescription, estoppel, pacta sunt servanda, okay, consent, and res judicata. These are general principles of law. When we say again consent, no, katong if there is any violation, then or you want to enforce that, for example, penalty or consequence, so it should be done with the consent of the state. Or in case of for instance, in arbitration case, there should also be consent that the other party submits itself to the jurisdiction of a tribunal. We also have res judicata. That means case has been decided, but it it has been concluded and decided already. Okay, we also have prescription and estoppel. No, ang example ng prescription and estoppel is when, for example, na ay land, no, and that land has no, perhaps it's owned by anyone, no, but it's not registered in the registry of deeds, no, walay title. So in that case, if it is occupied by a stranger, no, it's occupied by a stranger, and let's say 1,000 years or 100 years na, no, na pasa-pasa na sa iyahang mga heirs, then that would tantamount to estoppel or prescription, meaning dili na ka maka-claim sa imuhang right over that property because you have already slept into your right, okay, into your ownership of that property. That's an example of prescription, but anyway, you can understand them later on. Okay. There are supplementary rules of international law and found in judicial decisions and teachings of highly qualified publicists of various nations. They are subsidiary means for determination of rules of law. So these are general principles, no, katong mga decisions sa Supreme Court. However, these decisions of the Supreme Court are not considered to be it's not within the realm of stare decisis, no. When we say stare decisis, kanang it is binding to the succeeding cases, meaning you can use that as a basis in determining the issue of the succeeding case or in resolving the succeeding cases. What are examples of this? No, we have Chorzo Factory. It was decided by the PCIJ. Every violation involves the obligation to make reparation. No, so diba in warfare, for instance, there should be reparation for the damages caused. Also, private rights gained under one regime do not cease upon a change of government. Okay, so there's continuity as always. Okay, also the principle of estoppel. So these are the examples of general principles of international law. Let's talk about the secondary sources. No, we also have judicial decisions, or Article 38 does not distinguish between those rendered by international tribunals like ICJ and arbitration bodies and those promulgated only by national courts. So again, there is no distinction. So any decision made by an international court, no, or outside the domestic court, then it's considered as a judicial decision under the contemplation of international tribunals or international courts. Decisions of every country show how the law of the nations in a given case is understood in that country and will be considered adopting the rule which is to prevail in this. So the doctrine of stare decisis is not applicable in this case. No, in domestic sphere, no, we also of course apply the concept of stare decisis, meaning kung ano yung ruling, provided that the succeeding cases or issue has the same facts and perhaps same nature with the previously decided case, then you can apply stare decisis principle, no? Okay. Kung sa tuwa pa na siya, for example, na ay ruling about let's say a 16-year-old committed a crime against C, no, or against B. Okay, tapos later on, okay, there's also a case similar to that, but in that case it's a 17-old boy committed also a crime against another person. So what was the decision of the first case? No, katong pinakauna to the 16 years old, it's acquitted, no, or it has no criminal responsibility kay minor man. So sa succeeding case na napoy 17, is 17-year-old boy a minor? Yes. So you can apply the previous case. That's what we call stare decisis. Okay, so the doctrine of stare decisis is not applicable in international law, and so the decision of the court has only persuasive value in the decision of subsequent case. That's why it can be incorporated or integrated in the so-called general principles of law. You get that? We also have writings of the publicists, mga authors. Okay, luminaries of international law. In order to qualify as secondary sources, they must be a fair and unbiased representation of international law and acknowledged authority in the field. Mere credentials are not enough, as the jurist may have been motivated by national pride or interest. So when you become a writer, or your opinion can be considered as a secondary source of international law, again, you must free yourself of any personal opinion. But of course, you just have to think about the facts, think about the issues objectively, and you do not, or your national pride or interest should not affect um, your opinion on a certain matter. In interpreting a rule international, or in supposing the existence of a rule which does not in fact form part of the law of nations. We also have the concept of equo et bono. This refers to the application of equity as a source of international law. But again, in a domestic sphere, we do not we don't follow the rule of equity, because ours is a law of justice, no, or a rule of law, no, meaning we follow what the law is saying, no, what the provisions of the law is claiming or whatnot, no. But again, we only apply equity in domestic courts if there is absence of statutory provisions, meaning walay balaod na available. So if there is no law available, then you rule the the you follow the rule on equity. The ICJ, although not expressly authority by the statute to apply equity as from distinguished with law, has some freedom to consider some principles of equity as part of international law, which it must apply. So I submit that kung wala gani available na international provision with respect to certain issue, then we can apply the law on equity. But if there is no such statutory laws, statutory provisions applicable to a certain case, then definitely, no, you don't use equity. You apply what's written in the law. Equity, when accepted, is an instrument whereby conventional or customary law may be supplemented or modified in order to achieve justice. So, opinion juris, it means an action that is carried out of a certain practice is followed because of a belief that it is a legal obligation. So it is dependent on the belief of the states or the members of the international community na, oy, this policy has been recognized by majority of the members of the international community. Oy, we believe that it's binding. So that's what we call opinion juris. These actions or practices could become a custom. Once it becomes a custom, it becomes a primary source of international law. In international law, opinion juris is a subjective element which is used to judge whether the practice of the state is due to a belief that is legally obliged to do a particular act. So it's subjective rather than objective, because again, what's important here is the belief of the state party in claiming or in believing that certain policy international community is obligatory or has an obligatory force. In opinion juris, not only must the acts amount to settled practice, but they must also be such or be carried out in such a way as to be evidence of a belief that this practice is obligatory, with the existence of a rule of law requiring it. Okay, so that would be all for chapter 2. Let's proceed to chapter 3.